Everyone, and welcome to the 16th annual Grotius Lecture. I'm Claudio Grossman. I'm the Dean of American University, Washington College of Law. It's my great pleasure this afternoon to introduce our 2014 Grotius Lecturer, Professor Radhika Kuramasawi, and our distinguished discussant, Professor Diane Marie Amen. The Grotius Lecture began as a partnership between the American Society of International Law and American University, Washington College of Law. Today, we celebrate the 16th anniversary of this lecture, presenting important voices on vital issues in international law. It would not be an exaggeration to say that the lectures have become a tradition. In Washington, anything that happens more than once is a tradition, as a matter of fact. Hugo Grotius captured the spirit of his time by identifying norms and principles capable of providing the legitimacy of law to decision-making in the realm of international relations. His ideas paved the way for international law to evolve into a system we know today. Our presenters today, Professors Kumaraswamy and Amen, join a distinguished group of speakers who have occupied this podium, embodying the commitment to a rule of law in international relations. This year's Grotius lecturer and presenter could not be more relevant for today's topic, quote, women and children in international law, end quote. Both of them began their distinguished careers as legal practitioners and academics and have had a tremendous impact on students and the society at large. Professor Radhika Kumaraswamy, the Grotius lecturer, has advocated for women and children in many countries in the world, Afghanistan, Somalia, and Thailand, just to name a few, empowering people and educating societies in the protection and promotion of important values. Most recently, as the UN Under-Secretary General and Special Representative of the Secretary General for Children and Armed Conflict, she has been in charge of preparing the annual report of the Secretary General on Children in Armed Conflict. This report is compulsory reading. It covers and makes recommendations regarding an array of key issues, including the evolving nature of armed conflict and emerging challenges for child protection, enhancing compliance by armed forces and armed groups, and grave violations committed against children during armed conflict. Her voice is powerful and clear, both in exposing this inhuman practice of recruiting children and telling ways and suggesting to international community what we can do to stop it. In her positions with the UN, including serving with distinction for nearly a decade as first UN Special Rapporteur on Violence Against Women, Professor Kumaraswamy is known for raising awareness of the actual impact of international law. Professor, we thank you for your service and will welcome your remarks shortly. It is also my pleasure to welcome this evening distinguished discussant, Professor Diane Marie Amen. Professor Amen is the Emily and Ernst Woodruff Chair in International Law at the University of Georgia Law School. She is also an affiliate faculty member of the university's African Studies Institute. As an expert of international law, Professor Amen teaches courses such as Public International Law, International Criminal Law, and the Laws of War. She is also a frequent commentator on national and international media and publishes in English, French, and Italian. Her blog on media topics in international law demonstrates just how effective she is at communicating about these topics. In addition to teaching, she serves as the International Criminal Court Prosecutor's Special Advisor on Children in Armed Conflict. Professor Amen, also we're honored to have you with us today. I wish we would have time to say more about the life of these two exemplary women, but I encourage you to look at your programs for a more complete bio. The rights of women and children comprise some of the most important issues in international law. Women and full realization of those rights is still far from where it should be. Women's and girls' access to education, for example, is a vital topic in the world. In numerous societies, women and girls continue to be discriminated against even de jure. Reacting against the social construct recognizing that Mother Nature was not to be blamed, our own law school, founding mothers Ellen Spencer, Massey, and Emma Julie established our law school in 1996 to open the gates for men and women to study law and develop themselves to a full potential. Much remains to be done by all of us, however. In this hemisphere, 1 out of every 4 women is the object of domestic violence, and that would be enough to mention. We witness femicide, female genital mutilation, and brutal expression of discrimination, including in human treatment and torture in many societies. In no society we have full equality in practice. Concerning children, and I will stop here, it will be enough to mention that the UN Millennium Development Goals and Beyond fact sheet of 2013 reports that there are over 100 million children under the age of 5 undernourished and underweight, threatening humanity's future. However, this data should not lead us to a narrative of despair or inevitability. Characteristic of our time is the mobilization of women and men that imagine and want to achieve a better world where all human beings are free to develop their full potential. And we see in the human rights narrative that unites all of us a common language of dignity, a tremendous and powerful force that embodies the aspiration of women, men, and children to imagine and create a better world. Our 2 speakers today are themselves examples of this powerful force because of their commitment to contribute to it through the rule of law. They are role models for all of us. Without further delay, please join me in welcoming to the podium our distinguished expert and this evening Grotius lecturer, Professor Radhika Kumaraswamy. Thank you very much.
Thank you very much, Dean Grossman. I want to thank the American Society of International Law and American University for inviting me here to give the Grotius lecture. As you know, the title of the lecture is Women and Children, the Cutting Edge of International Law. So I want you to sit back and relax, because it's a bit of a longish lecture, because this is, after all, my life's work. Thank you. Sometime at the end of 2011, while I was still the United Nations Special Representative of the Secretary General for Children in Armed Conflict, I met an ambassador from an Asian country just before a United Nations Security Council meeting on children in armed conflict. He told me that I was leaving the United Nations at the right time. He said the era of human rights is over. It has been shown up for what it is, a product of Western liberalism, and now a modern-day foreign policy weapon of Western imperialism. A few months earlier, I was in the Central African Republic with 3 generations of women from a family who had been brutally raped by the forces of Jean-Pierre Bemba when he entered the Central African Republic from the Democratic Republic of Congo in 2002. They were getting ready to go to The Hague to testify against him. They described the events in detail, and I could feel their sense of vindication and hope. Even if Bemba was not convicted, they found consolation in the fact that someone recognized the crimes committed against them. This is then the complexity of human rights in the modern world. Increasingly, member states, along with individuals and groups in the global south, challenge both the epistemology and the practice of human rights. But despite their efforts at the grassroots level, there's a groundswell of support for the idea of human rights, including women and children's rights, as more and more groups begin mobilizing using the discourse and strategy of the human rights movement to fight for equality and social justice. In the traditional world of international law, issues of war, peace, and security have always taken precedence over other developments. The Westphalian origins led to a focus on the dispute resolution and the establishment of an international order that will enable peace. Even today, the media attention of the world remains on the Security Council, whose proceedings dominate the discussion of international law and international relations. However, hidden from the view, away from the drama of the use of force and international peace and security, there has been a quiet, creeping revolution in the area of women's and children's rights at the international level, which may have far-reaching consequences on how we think about international law and its place in the modern world. I have divided this lecture into 3 parts. First, I will try and identify 5 ways in which women's rights and children's rights have impacted on the substance and procedure of international law, especially in the last few decades. Second, I will try and describe the backlash against some of these developments, leading to a certain paralysis in their contemporary evolution. Thirdly, I will attempt to identify a way forward for the future, always keeping the interests of women and children in mind. Before I proceed, I would just like to make 3 short caveats. First, international human rights law is often seen as a sub-regime of international law. In the same way, women and children's rights are a sub-regime of international human rights law with a level of autonomy and integrity relevant to their specialization. Nevertheless, as we will see later, what happens in the international arena to the regime of human rights also affects issues relating to women and children and vice versa. Second, though I have brought the issues of women and children together for the purpose of the lecture, we must recognize that there are strong differences between these mandates. Women are adults, and their main quest is for empowerment and equality. Though there are similarities between women and children when it comes to matters of protection during war, there are major differences in the quality and nature of their agency and the right to participation. I do not want it to be seen in any way that I aim at infantilizing women in putting these 2 categories together. Third, I spent a great deal of my life as a researcher and an academic working for a think tank in Sri Lanka. I was also fortunate to have experience of being the United Nations Special Rapporteur on Violence Against Women and the Special Representative of the Secretary General on Children in Armed Conflict. The tension between the world of ideas and the world of the practitioner is particularly interesting to me, as over time I have found that what is ideal is not doable, and what is doable may actually compromise one's ideals. Let me now go into the first part of my lecture, the 5 ways in which I think women's rights and children's rights have impacted the substance and procedure of traditional international law. Let me list these 5 ways at the beginning. First, women's rights and children's rights have had a unique impact on the process of creating international law and its relationship to state practice. Second, more than any other issue, the question of women's and children's rights pierces the veil of state sovereignty, the foundation of traditional international law. Thirdly, women and children's issues have led to a rethinking on how to deal with non-state actors within the framework of international law. Fourthly, since the 1990s, international criminal jurisprudence has developed new and innovative doctrine with regard to crimes against women and children, with pioneering efforts by the ad hoc tribunals and the International Criminal Court. And finally, the role of NGOs and international civil society involved in women's and children's issues has been unprecedented at the international level, forcing a recognition of civil society and its role in international deliberations. Let me now go through these one by one. With regard to the process of creating international law, those of us who are old enough to remember the old masters of international law must recall how it was drilled into us that only decades of state practice, without objection, creates the sense of legal obligation that is the basis of international law. This may be supplemented by treaties, which generally tended to be bilateral and concerned with issues of peace and security or trade and commerce. Jose Alvarez has documented the revolution that has taken place since the 1970s in the realm of treaty making, and the proliferation of international multilateral treaties creating obligations and standards on a whole host of matters. Treaties usually negotiated under the auspices of the United Nations. The Convention on the Elimination of Discrimination Against Women and the Convention on the Rights of the Child were also drafted during this period. However, the Women's Convention and the Children's Convention are unique. This uniqueness was not in their multilateral nature, but that instead of codifying practice that was already in existence, they tried to actually transform the practice of states at the national and international level. They imposed positive duties on states, and even at times tried to transform the behavior of individuals within nation states. Sedo Article 5A is one such example. It says, state parties shall take all appropriate measures, A, to modify the social and cultural patterns of the conduct of men and women. And then it goes on with the rest. As is well known about CEDAW, for example, it truly pushes the frontiers of international law, imposing obligations on issues of equality, protection, and transformation at the same time. It includes both political and civil rights, as well as economic and social rights. It deals with both public and the private sphere. Though it is revolutionary in substance, it accepts a gradualist approach, stating that, quote, appropriate measures be taken without delay, unquote. This transformative impetus was a product of the intellectual climate of the 1960s and 1970s and continued with vigor at the international level well into the 1990s. That fact that we had come a full circle from 100 years of state practice leading to the creation of international law to an era where multilateral treaties attempt to change state practice and the behavior of their citizens is one of the unique developments of the latter half of the 20th century. The problem with transformative projects, especially those originating at the international level, is the gap between aspiration and implementation. Both the Women's Convention and the Children's Convention are the most ratified conventions in the world. However, the Women's Convention has so many reservations by a diverse number of states that its value as a normative standard sometimes raises doubts. The CEDAW committee, taking the lead from the Human Rights Committee, attempted to rein in these reservations, but due to the advice of the UN Council, they abandoned this effort. The ICJ, in its determination on the Genocide Convention, it argued that universality is an important goal of human rights and humanitarian treaties, and that some measure of state flexibility should be allowed as long as reservations do not violate the object and purpose of the treaty. In the area of women's rights and CEDAW, we do have a serious question on how the desire for universality of membership can often trump the integrity and coherence of multilateral treaties. Nevertheless, there is no doubt that concerted intellectual action can change national policy and practice. When I began my tenure as Special Rapporteur on Violence Against Women, a year after the UN Declaration on the Elimination of Violence Against Women, I wrote to countries and found that only a handful of them had addressed the issue of domestic violence in any form. When I left 9 years later for my final report, I wrote again to the countries, this time after a decade of international activism and also the Beijing conference. This time, every country except Bhutan had passed either legislation or formulated national programs to deal with the issue. Given the lack of capacity that many states to implement their programs, there may not have been an immediate effect on the ground. In fact, during my state visits, I noticed that governments present grand plans to combat domestic violence or trafficking, usually drafted with the help of a UN agency. However, after that, nothing may happen because the criminal justice system may lack capacity and the government may not have adequate political will. Nevertheless, international activism on violence against women resulted in a sea change in attitudes and a growing awareness about the importance of dealing with this once very invisible issue. It has to be said that the political and intellectual climate is different now. Transformative ideas and imaginative projects for the law at the international level are in retreat. Postmodernists and conservative scholars alike believe that practices should evolve from the community and not be imposed from above. The utilitarian framework of the now dominant law and economics movement in Western universities emphasizes efficiency and gradualism. Therefore, transformative projects have become unfashionable. And yet it could be argued that this return to a conservative evolutionary framework was made possible because of the dramatic push given by feminists in documents like Sedo and Devo. Once the lines were marked in the sand and awareness raised, one could then afford the luxury of focusing on nuance, context, and efficiency. Now let me discuss the issue of piercing the veil of state sovereignty with women and children's issues. At the time the United Nations was created, there was a general consensus that state sovereignty would be the foundation upon which the international order would rest. The process of decolonization around the world only accentuated the structure. The initial efforts by the UN system with regard to human rights were relegated to only the passive stance of setting of standards and a refusal to deal with developments within countries. Soon, however, the movement against apartheid in South Africa, the movement against disappearances in Latin America, and the struggle for democracy in Eastern Europe, Latin America, and East Asia resulted in a gradual piercing the veil of state sovereignty. Given these movements, one could argue that national sovereignty really has two elements: state sovereignty, that is the foundation of traditional international law, and people's sovereignty, which one could argue is the element in the regime of human rights. It must not be forgotten that the United Nations Charter begins with "We the people." Of all the concerns before the international community, no other issue pierces the veil of state sovereignty as much as the issues concerning women and children. As they attempt to change practice and even individual behavior, they not only impose positive duties, but also pass judgment on national attitudes and stereotypes. In the area of accountability for international crimes and rights and violations against women, within the issue of women and children go the furthest. Within the UN system, these two issues have the most extensive system of network of monitoring and reporting. All three pillars of the UN system have monitoring mechanisms with regard to women and children. If one looks at the special procedures of the United Nations Human Rights Council, there are 5 related to women and children. The Economic and Social Council oversees 2 treaties, Sedo and CRC, with the largest amount of state signatories and their own very activist treaty bodies. A session before either of the treaty committees who have been briefed by the shadow reports of NGOs can be a very grueling process. The Security Council, that once was averse to any human rights issue being brought before it, has since 1999 accepted 3 important thematic mandates. The first was children in armed conflict, the second was sexual violence during armed conflict, and the third related to protection of civilians. All 3 before the Security Council are related to issues concerning women and children. The first 2 have elaborate monitoring reporting mechanisms on the ground at the field level within countries involving all UN agencies and some NGOs. And the task force that finalizes these reports is chaired by the head of the UN system in the country. These reports that go directly to the Secretary General via the special representatives on children in armed conflict and sexual violence also contain name and shame lists of states, armed groups, and individuals that commit systematic violations against children and women. It is envisioned that persistent perpetrators will eventually face targeted sanctions. With regard to the Democratic Republic of Congo and Somalia, the sanctions committees have included crimes against children and women. Individuals in the Democratic Republic of Congo and Cote d'Ivoire have had sanctions imposed against them because of their violence toward women and children. The involvement of the Security Council on these issues has raised some concerns, especially after the doctrine of the responsibility to protect. The power of the women's and children's movement to leverage the Security Council is a new and welcome development, forcing the Council itself to deal with the consequences of their actions on civilians. However, this new power should also be used judiciously. It has already proved useful on the ground, but as mentioned later, partnership with national women and children's groups working at the community level is essential for this to be a true success. Besides the concerns of these three main organs of the United Nations, there are also two full-time UN agencies that are fully involved in the issues of women and children. UNICEF, the largest UN agency, as perhaps its most successful, is wholly dedicated to the concerns of children, and UN Women, created recently, amalgamating all UN agencies working on women, are fully engaged with the large ambit of women's issues. At the Secretariat, as I said earlier, there are two full-time Under-Secretary Generals, the Special Representative on Children in Armed Conflict and the Special Representative on Sexual Violence during Armed Conflict, devoted fully and full-time to issues related to women and children, and who report to all UN bodies and agencies and also conduct field visits to ensure compliance in the area of the mandate. This extensive and extraordinary network for monitoring and reporting at the international and national level does not really exist for any other human rights issue. Today, systematic information is now gathered on a regular basis on violation against women and children without the participation of the member state. Within the United Nations Development Programme, adopting a rights up front policy this year, the system of monitoring and reporting will be strengthened and tightened. In the area of women and children, the international system also goes beyond monitoring and reporting to the question of punishment. As outlined above, sanctions committees have imposed sanctions against people committing grave violations against women and children. In addition, if we look at the cases before international tribunals, some of the most important and path-breaking cases relate to war crimes and crimes against humanity in regard to women and children. As I said earlier, the system of monitoring and reporting, as well as punishment described above with regard to violation against women and children in the international system, are the most extensive you will find on any issue. Piercing the veil of state sovereignty has also taken other unique forms besides monitoring and accountability by international institutions. Since the treaties with regard to women and children are seen as aspirational, many states with a dualist tradition do not translate the provision into legislation. Increasingly though, especially in countries with a Commonwealth tradition of law, judiciaries are stepping into the breach, appealing directly to international law where national legislation does not exist. The most comprehensive case of these interventions was the Visakha case in India, where the Indian Supreme Court, drawing on recommendation 19 of Sedo, basically legislated on sexual harassment. This included a requirement that state companies and corporations that hire over 50 people must have a sexual harassment policy, as well as a committee to listen to complaints. This committee should have a majority of women in their composition, including an outsider. Other judiciaries that have drawn directly on international law with regard to women's issues are Botswana versus Unity Dao, the Nigerian Supreme Court in a case involving a cultural practice that permitted incest, the Mauritius Supreme Court looking at religious law, and the Malaysian Supreme Court on the issue of discrimination due to pregnancy. In fact, there is now an ongoing transnational judicial dialogue on many of these issues, and the adoption of the Bangalore Principles by a judicial colloquium that included Justice Ruth Bader Ginsburg and Justice Bhagwati of India, on guidelines on how to incorporate human rights norms in judgments in the absence of national action, where national legislation or practice conflict with these standards. Recent scholars have pointed to the fact that international relations are increasingly reliant on networks of groups, whether from civil society, state, or the professions. In the area of judicial incorporation, though many conservative judges still believe in judicial sovereignty, transnational judicial dialogue is increasing awareness, and in the case of women and children, leading directly to the judiciary appealing to international law. The veil of state sovereignty is also penetrated by UN templates and best practices supported by technical teams of the United Nations. This is available in a great deal of areas, especially those related to women and children. This kind of international law is sometimes criticized by international scholars who argue that this type of technocratic and bureaucratic intervention, not only for this issue, but for all important dilemmas in international relations, hides the politics involved and prevents innovation, creativity, and ownership at the national level. Nevertheless, today, UN templates and best practices are in place in a vast majority of countries, especially those coming out of conflict areas. For example, with regard to women, there is the Sedo Committee recommendation that 30% quotas of the seats of parliament should be reserved for women, as this is seen as a critical mass needed whereby women can actually influence the political process. As a result, in many of the countries emerging out of conflict with UN assistance, such as, for example, East Timor and Rwanda, quotas for women are now in place under their national constitutions. In addition to constitutions, model legislation is also promoted by the United Nations and other agencies in the area of domestic violence, trafficking, child labor, and child soldiers. Finally, at the community level, within nation states, international human rights norms with regard to women and children have in some countries pierced state sovereignty claims. Sally Mary has chronicled with this regard with the whole movement to combat domestic violence. She shows how laws and models developed in one part of the world are taken, modified, and transformed to suit local conditions. For example, in many developing countries, in domestic violence cases, the batterer is also often a victim of social justice and poverty. Therefore, in those societies, groups have tended to focus attention on the treatment for the batterer. As Sally Mary's research points out, international standards often do respond to actual needs in the community. The articulation of this need in human rights language gives legitimacy, particularly because countries have accepted these obligations. The standards and conclusion of UN treaty bodies become rallying tools for activists and individuals fighting for equality and social justice. This dynamic between international standards and local activists is perhaps the most exciting part of this chapter on recent developments in international law. David Kennedy has often criticized human rights groups who attempt to work with international standards. He argues that over time they have developed an entrepreneurship professional model of work, relying on donor funding and distancing themselves from the subjects of their concern. This is for the most part unfair, since professionalization does not necessarily mean less activism. However, there is also a modicum of truth in his comment on professionalization and the nexus between donors and some NGOs. In the 1980s, donors were far more responsive to the actual needs of countries and the actual project demands of NGOs and research groups. Today, they come with set agendas that are sometimes unhelpful in fighting for issues of human rights and social justice in a given context. It is important that human rights organizations listen to this criticism if they are to maintain legitimacy both at the national and international level. Donors, too, must rethink their recent strategies that are counterproductive and conceived in capitals far away from the real world in which women and children actually live. Now let me move on to the issue of non-state actors. Traditional international law is built, again, as I said earlier, on the foundation of state responsibility. However, over time, there has been a growing concern about the impunity enjoyed by non-state actors who also violate the rights of others. The 1980s and 1990s saw a vigorous campaign against impunity by non-state actors, by women's and children, by international groups, both through recourse to the concept of individual criminal responsibility under international humanitarian law, and by seeking to redress these issues within the framework of human rights law. The impetus began with the issue of disappearances, where state actors donning civilian attire were responsible for extrajudicial killings in Latin America. The state would avoid liability by claiming that private actors committed these acts. The celebrated Velasquez decision of the Inter-American Court finally responded to this terrible state of affairs by arguing that states have a due diligence duty to prevent, prosecute, and punish private perpetrators who violate the rights of others. The women's movement seized on this language in its effort to make violence against women a human rights issue. All UN documents dealing with violence against women articulate state responsibility for private actors with the requirement that states have a due diligence duty to prevent, prosecute, and punish those who commit crimes against women. There has been a great deal of discussion about what this due diligence entails. The main thrust of all the arguments have been aimed at ensuring that the criminal justice system respond to the issues with adequate training, resources, and commitment. In addition, there have been arguments that there should be an adequate support system for the victim. There have also been efforts by feminist jurists to make non-state actors who commit violence against women directly responsible for their crimes under international law, much like the individual criminal responsibility doctrine under humanitarian law. The late Professor Rhonda Copeland wrote a much-quoted article equating domestic violence to torture. International cases before the ad hoc tribunals and the ICC have also underscored the importance of recognizing individual criminal responsibility for crimes against women and children. As I mentioned, the Security Council is also targeting individuals. Though international individual criminal responsibility for war crimes and crimes against humanity is very needed, excessive criminalization of crimes within nation states may actually cause problems. One of the foremost theorists of human rights, Sir Nigel Rodley, whom I saw here, is he still here? Yes, he's still here, warned the women's movement in the 1990s about the pitfalls of this trajectory. Human rights is a doctrine that has been primarily a watchdog of the state. He argued that new approaches to fight violence against women leads to an unhealthy partnership between women's rights groups and the criminal justice system. He warned that the fight against impunity might end up as something else. 20 years after the initial movement, one must confess that there is some truth in that warning given to us by Sir Nigel. Certain areas of violence against women, such as trafficking and sexual violence, have become movements that are more about punishment of individuals rather than the rights of victims. Celebrity after celebrity, politician after politician are now becoming shrill and demanding immediate action, translated as punishing the perpetrator. The prosecutor is now in the forefront of these issues, not the human rights activist. In India, during the aftermath of the horrific gang rape of a paramedical student, certain women's groups call for public castration and the death penalty, not very human rights friendly demands. There is a concern that what began as a women's human rights movement may turn into a law and order punitive movement. David Garland has written extensively on the American penal state of recent years and the emergence of an ideology based on punishment and victims' rights. Victims' rights should not be dismissed. It is very important. I've spent my whole life on it. But that their violations must be acknowledged and victims' claims must be taken care of. But it is also important to ensure that the response is not within a framework of personal retribution and revenge, but it must be within the framework of human rights and rule of law. Excessive criminalization also takes away other possible approaches, such as restorative justice, that combined with punishment may be more appropriate in certain contexts. Now let me just say a word about international criminal law and how the women's and children's movement has affected that. The creation of the International Criminal Court saw for the first time the clear articulation of sexual violence in all its forms as a war crime and crime against humanity. Until the grave breaches provisions of the Geneva Conventions led to a great deal of ambiguity, debate, and prosecutorial creativity, since they did not specifically mention sexual violence. This dramatic development in international criminal law was made possible as a result of the constant lobbying of a broad group of women's rights activists drawn from all the countries of the world. Since the 1990s, with the creation of the special tribunals for former Yugoslavia and Rwanda and the International Criminal Court, international criminal law has developed at a rapid pace. Interestingly, much of the jurisprudence that is being produced has been in the area of issues related to women and children. For the first time, there is now an international definition of rape, following a great deal of discussion. The definition attempts to signal the importance of recognizing the gravity of the crime and the powerlessness of women in the context of armed conflict, while also protecting the rights of the defendant. Rules of evidence, in particular Rule 96 of the ICTR and the ICTY, have also been developed that are now state-of-the-art, setting clear guidelines of what kind of evidence may be produced during rape trials. Procedures for the protection of victims and witnesses were also new and innovative. All these developments may in turn actually influence rape proceedings at the national level. The ICC also for the first time defined what it was to be a child soldier, what it means to conscript, enlist, or use children to participate actively in hostilities. Using a broad case-by-case approach, the court focused not so much on the functional role of the child, but on whether he or she have been exposed as potential targets with consequential risk. For international lawyers concerned with women's rights and children's rights, these are interesting and exciting developments in the field of jurisprudence. The formulation of international definitions and standards may also have demonstrative effect and influence national law. And finally, in this section, let me say something about international civil society. Until the 1990s, NGO participation at multilateral institutions was a very limited affair, pertaining primarily to the lobbying of states, with a few select NGOs being given the right to participate in the proceedings. The Commission on the Status of Women, the Women's Convention, the World Conferences that took place on women's issues, along with the work of the Children's Committee, changed all that. These two areas became pioneers in envisioning a more active role for NGOs. For example, both the Sedo Committee and the CRC Committee entertain shadow reports prepared by the NGOs on the compliance by a particular member state. These reports are taken very seriously and are often the basis for questioning member states and in formulating conclusions and recommendations. Catherine Sikink describes a network of women's NGOs drawn from northern and southern countries that push for violence against women to be included in the human rights agenda of the United Nations. Till the 1990s, violence against women was a taboo subject, and only issues relating to discrimination, primarily in the workplace and in the family, were discussed at the international level. CEDAW, for example, has no mention of violence against women, and it was only in the 1990s that Recommendation 19 was formed. An extraordinary movement of women across regions and cultures fighting against domestic violence, trafficking, systematic rape, brought the issue of violence against women to the World Conference on Human Rights held in 1993. They were so convincing and drawn from such a broad range of countries that by the end of the year, the United Nations General Assembly had passed the Declaration on the Elimination of Violence Against Women, and within the year, the UN Human Rights Commission created the post of Special Rapporteur on Violence Against Women. This same network of NGO women expanded and worked tirelessly on issues relating to sexual violence during armed conflict, resulting in the Statute of the International Criminal Court having one of the most comprehensive definitions of sexual violence contained in any international legal document. In the case of children in armed conflict, again, it was the humanitarian children's NGOs working in conflict areas that pushed hard on this issue, forcing the United Nations General Assembly to request Rasa Michel to convene a study in the 1990s. Immediately after that report, the General Assembly created a full-time Under-Secretary General post for a special representative on children in armed conflict. The NGOs continue to have a close watch on these developments. Including this section about the 5 areas where the issues concerning women and children have impacted on international law and procedure, one has to reflect on why multilateral fora are more responsive to these issues and not others. Children's issues particularly draw a broad consensus at the United Nations. Perhaps these issues play to the nobility and the self-image of nation states and their citizens as the protectors and rescuers of vulnerable women and children. No state wants to go on record as being against them. It is this discomfort that is often exploited by the more experienced UN officials and NGO activists to push the agenda forward in a sustained and deliberative manner. Now let me get a little more polemical and move on to the backlash to this movement. I would like to move now to the second part of the lecture, which will attempt to understand some backlash against the human rights movement in general and women's rights and children's rights in particular that began at the turn of the century. I will discuss 3 aspects. First, the impact of Kosovo, Iraq, Afghanistan, and the doctrine of humanitarian intervention on third world perceptions of human rights, including women's and children's rights. Second, I will discuss the attempt to place the issue of sexuality on the international agenda and the repercussions for women's rights. And finally, I will say a word about the backlash to international mechanisms of accountability, as many of these mechanisms, as you know, deal with women's and children's issues. With regard to humanitarian intervention, the tremendous growth of human rights in the 1990s and the emphasis on women's rights and children's rights in particular was unprecedented and possible because of the end of the Cold War and the removal of dictatorship in Latin America. With a large number of countries from Latin America and Eastern Europe coming into the United Nations, supporting the human rights agenda, there were proliferation of human rights mandates and state acquiescence in the growth and expansion of human rights. Kosovo, September 11th, and the war on terror dramatically changed this atmosphere. These developments, coupled with the new doctrine of the responsibility to protect, brought in the prospect of humanitarian intervention through military use of force to protect civilians, chief among them women and children. In Afghanistan, the protection of women was often articulated as one of the main reasons for military action. These developments deeply worried countries of the global south, where it was felt that human rights issues, and particularly women and children's issues, would become a cover for a new form of imperialism. The protection of women and children that in the 1990s received universal support, even in the Security Council, is now facing a measure of resistance. This prospect of humanitarian intervention has also rekindled the strident discord of state sovereignty that had been in abeyance in the years following the end of the Cold War. Many countries of the global south, especially those with unattractive human rights records and led by national elites that still remember colonialism, have begun to reassert the doctrine of state sovereignty, which they claim is the pillar of international law. They again point out that the concept of human rights in its present form is the product of the European Enlightenment and were adopted without the participation of third world countries. They also assail the selectivity and double standards when it comes to human rights, which when combined with posturing usually have colonial overtones. Whatever the original philosophical roots of human rights, most countries consent to the framework when they sign the United Nations Charter and when they enter into treaties. With regard to women and children, the overwhelming ratifications, despite reservations, signal the fact that states consent and aspire to reach the goals set out in these conventions. We are not talking about self-evident Kantian principles, but a regime based on consent in line with the thinking of philosophers such as Richard Rorty. Whatever the philosophical misgivings and intellectual challenges, states do consent to things so that they can do practical business in the public sphere. Therefore, consent surely is a valid basis from which to expect compliance, regardless of the specific history of a nation state. In addition, it must be remembered that the first time the United Nations acted using a human rights situation was in response to the call of the people from the South, in the case of apartheid in South Africa and disappearances in Latin America. American legal scholars focus on Helsinki Watch and Human Rights Watch as the originators of international human rights, but the truth is that within the United Nations, it was apartheid and disappearances that first forced the Human Rights Commission to move beyond the passive stance of standard setting to monitoring, reporting, and activism. To ignore this history is to belittle the struggle of so many people and groups around the world. As for double standards at the international level, there are few honest intellectuals who would contest this claim, and there is no doubt that double standards do exist. A great deal needs to be done to face this issue squarely. However, the response to this dilemma cannot be to paralyze the entire international system. Double standards even exist in national systems, but the answer cannot be to set criminals free and encourage widespread impunity. The humanitarian approach appears to be the most pragmatic one, a case-by-case approach where it is believed that justice for one person is better than justice for none. Though at the macro level, the argument of double standards appears forceful, it is never an answer for the individual demands of victims, many of whom I have met in person and whose suffering and need for remedy far outweigh purely the intellectual claims searching for a global balance of power. I think I'm going to move on a little. I didn't realize it was that long. Let me just get to the, I was going to give a big lecture on post-colonial thought, which will probably put you all to sleep, so then I will just move on to the issue of of sexuality, perhaps. And we can perhaps have this published somewhere where you could read the other issues later. In addition to the general backlash against human rights that has affected women's rights and children's rights since 2001, there have also been particular developments within the respective fields that have led to a slowing of momentum with regards to activism on these issues at the international level. For the most part, the international women's movement was united around the issue of discrimination in the 1980s and violence against women in the 1990s. However, in the early 1990s, path-breaking writers such as Judith Butler began to question the category of what constitutes woman from the perspective of gender identity, arguing that gender categories are more fluid than biological. Many Western NGOs and academics began placing the issue of sexuality on the international agenda. Most feminists, even today, believe that sexuality is at the root of many issues relating to women, from discriminatory cultural practices to violence against women. In addition, there is the international sensitive issue of sexual orientation. The issue of sexuality first came up at the International Population Conference in the 1990s and then in the World Conference of Women held in Beijing in 1995, where member states recognized some measure of sexuality within the sphere of reproductive rights and accepted the notion of reproductive autonomy. However, there was a desire to go further to recognize sexual rights independent of reproduction and to allow for the protection of sexual minorities. This emphasis on sexual rights by Western feminists was not well received by most countries of the global South, many of them strong believers in the Catholic and Islamic traditions. Their conservative positions were supported by the change of administration in the United States, which was deeply suspicious of reproductive rights. This combination resulted in pushback not only on sexual rights, but also on some aspects of reproductive rights, so much so that European member states and UN agencies were again afraid to call for a world conference in 2005 as expected, afraid there would be a rollback of hard-earned gains. This polarization continues because of the suspicion on both sides. All negotiations have become arduous and long, where unanimity was once easy and simple. There was a glimmer of hope this year when, in the wee hours of the last night of negotiations in March 2014, member states agreed to make gender equality a standalone goal for the next millennium. Now, let me just say a few words about the way forward and then end. Given the impasse that currently holds sway on many of these issues, what is the way forward? And I'm just going to talk about one aspect, though I've mentioned three. The most important necessity today is to win back the full support of the Global South for issues relating to human rights in general and women and children in particular. The first step in this area is in the area of advocacy and to find the correct balance between moral outrage and the understanding of nuance and context. Nothing upsets third world people more than the arrogant tone to see a galaxy of Western celebrities, politicians, their wives, assisted by their sensational sound bites of the 24-hour news cycle, pass quick judgments on countries and cultures of the South. And yet one must be honest. As I've experienced in over 2 decades of advocacy, it is moral outrage that moves the system. It is moral outrage that shames governments and individuals, and they do change course. It is also moral outrage that compels donors to give money to causes. All of us in the field of advocacy have deployed a moral outrage to raise awareness on important issues. However, moral outrage, to be effective, cannot be selective and must involve both issues of the North and the South. It must also be channeled through important national partnership. Moral outrage on its own and the rescue of particular individuals will not change matters in the long term unless one simultaneously works for national and community ownership of the policies and programs that combat trafficking. Let us take the area of trafficking, where many strong laws exist today. The framework proposed and led by US and Swedish activists with the active involvement of the US State Department is punishment-based. The assumption is that you criminalize the trafficker, penalize the client, and rescue the victim or sex worker. Punish and rescue is the effective slogan. Though this sounds noble, no one stops to ask why one of the girls rescued by Nicholas Kristof actually went back to the brothel. My experience with trafficking in Poland, Nepal, and India is that there are really horrendous cases of abduction and sexual slavery that have to be stopped at all costs. There's no doubt about it, punishment is important. However, it was very clear that the vast majority of women I interviewed wanted to migrate because of certain conditions at home, whether it be poverty, domestic abuse, or community oppression. The desire to migrate is then exploited by unscrupulous elements. The important aspect to recognize is that it is this woman or girl's desire to migrate that is at the root of the problem. Therefore, there's a close connection between migration and trafficking. Draconian laws set up without understanding this fundamental fact may only further victimize individuals concerned. When we discuss issues relating to trafficking, migration, or domestic workers, sex entertainment workers, or female factory workers, we are dealing with the survival strategies of women. We do not want to push them into a situation where we take away all these strategies without putting adequate policies and programs in place to give them other opportunities to pursue livelihood and make a better life. Punishment of the perpetrator alone will not suffice. We must do the empirical work to find out what is actually needed and what actual experience women are reaching. Now let me finally end with saying, in conclusion, let me say that there is a silver lining for all of us who have worked on issues relating to women and children at the international level. At the moment, the United Nations is reviewing the Millennial Development Goals that were set as we emerge into the 21st century. The most spectacular development has been in the area of girls' education. Girls are now entering schools in large numbers, but in a few countries in Latin America, the Caribbean, and some parts of Asia, they actually dominate all the faculties of the university except engineering. Whether these gains will actually translate into employment gains given the glass ceiling and the dual burden of motherhood and employment has yet to be seen. It is therefore not surprising that Malala, the feisty young lady from Pakistan, has become the icon of this development. Some within Pakistan have argued that she is being manipulated by Western powers, and she must guard against becoming solely a media figure and a superficial celebrity. But in my field work in the Somalian refugee camps in Kenya or among girls in Afghanistan, I found that Malala is not alone, and girls all over the world are clamoring for education. In Afghanistan, I met a girl called Aisha, whose house had been bombed by US warplanes and whose girls' schools had been attacked by the Taliban. She was undeterred. She was going back to school, and she told me with steely determination that she was going to be a teacher. I found the same steel in a girls' school outside Jalalabad under threat from extremist forces. They were celebrating since one of their own had got into medical school, and another told me she was going into politics to run for governor. As the generation of women around the world who first raised issues of discrimination and violence against women begin to grow weary and retire, it is this next generation of feisty, articulate, self-confident young women, especially from the global south, who will take this agenda forward. We can only wish them well. I would like to conclude today by dedicating this lecture to my mentor, Neelan Thiruchelvam, and his wife, Siddhi Thiruchelvam. Neelan was a prominent lawyer and academic who visited at Harvard Law School and a politician. He was also a builder of institutions for civil society activists and free-thinking academics. Siddhi was a leading corporate lawyer and a human rights activist who was also a deeply moral and caring person. As you know, Sri Lanka lived through many decades of civil war. While fighting raged in the battlefield, the intellectual atmosphere in Colombo and in the diaspora was often vicious and vituperative. Extremists on both sides, as well as enabling elements within the Sri Lankan government, attempted to silence all other voices, especially those who stood for pluralism, human rights, social justice, and peace. In this toxic atmosphere, Neelan and Siddhi provided a space for a whole generation of scholars from all ethnic groups, both in Sri Lanka and South Asia, to exchange ideas and debate some of the most crucial issues of our times. Neelan gave leadership at the workplace, and conversations continued in Siddhi's nurturing living room. Those were exciting times, and pioneering research was conducted as lawyers, anthropologists, social scientists, and artists gathered at the institutions that Neelan founded to exploit the creative space provided by him and his colleagues. Interns and scholars from around the world, many of you in this room, Some giants in their field, some just beginning their scholarship, flocked to enjoy the atmosphere, the debate, and the repartee that often took place in the thatched patio at the International Center for Ethnic Studies. In the end, Neelan paid with his life for his humanity and moderation when the liberation tigers of Tamil Eelam assassinated him in 1999. Sithi bravely continued his work and died just a few weeks ago. Both Neelan and Sithi died broken-hearted, seeing the Sri Lanka they loved being torn apart, not only by brute physical force, but by ideologies of violence and hate that have deeply damaged our minds and our hearts. In 100 years' time, when the history of Sri Lanka is finally written by objective, dispassionate observers, Neelan and Sithi will have a central role in that narrative as some of the few passionate individuals who kept alive the traditions of humanity and dignity in a war-torn Sri Lanka, traditions that we now seem to have lost along the way. Thank you.
Thank you, Professor Kumaraswamy, for your thoughtful presentation. And now it's my great pleasure to invite our distinguished discussant, Professor Diane Marie Amen.
Good evening. I have entitled my response, the I may never be able to say this right, the post-colonial woman or child. I deliver these remarks in my personal capacity. They don't in any way reflect the views of the Office of the Prosecutor of the ICC. Let the child be excused by his age, the woman by her sex, says Seneca in the treatise in which he vents his anger upon anger. So wrote the namesake of this lecture, Hugo Grotius, in his masterwork entitled The Law of War and Peace. With that quotation, let the child be excused by his age, the woman by her sex, Grotius traced to the writings of an ancient Roman philosopher the injunction against harm to women and children in time of war. Grotius' reiteration of Seneca's words tacitly admitted that as late as 1625, armies were still violating that injunction. Sadly, the same is true today, 389 years later. Today, neither women nor children are excused from wartime assaults, violence, and upheaval. In Syria alone, 3 years of conflict have left well over 100,000 persons dead and forced another 2.5 million persons to flee their country. Women and children are included in those statistics. Conflicts elsewhere generate similarly grim numbers, as Professor Kumaraswamy indicated by her references to the Central African Republic, to the Democratic Republic of the Congo, and to her own homeland of Sri Lanka. Indeed, outrage at the persistent violation of laws protecting women and children undergirds the Grotius lecture that you have just heard. Commensurate with her distinguished career in international law academia, policy, and practice, Professor Kumaraswamy has presented a vast and intricate tapestry of global developments. It would be impossible for me to comment in full in the time allotted. Instead, I propose to pull 5 strands out of the fabric of her lecture and to weave them anew as a means to invite the imagining of a possible future, the future of the post-colonial woman or child. My first strand addresses Professor Kumaraswamy's statements of concern about certain post-colonial theorists. These scholars, she said, and I quote, reject the human rights framework as part of the liberal imperialist project, especially when it comes to cultural practices. They reject the dominance of the European Enlightenment and the sacredness of the power of reason, unquote. My own response might raise hackles among some of those very scholars, for it begins with this claim: we are all post-colonials now. By way of example, both of my own countries of citizenship are post-colonial states. One is Ireland. This is the 8th decade since the adoption of the Irish Constitution, a post-colonial charter from which India later borrowed. Yet, as demonstrated by this week's first ever visit to England by an Irish president, remnants of 8 centuries of colonization still litter both the islands. My other country is, of course, the United States. Here, the structure of government rests upon the post-colonial intuitions of the men who wrote its Constitution. Having won a revolution, these framers professed to borrow the best and reject the worst from their colonial past. The choices they made 200 years ago, admirable choices like the checking of power, and shameful ones like slavery, influence US policy to this day. To this day, moreover, Americans see themselves as having repulsed foreign tyranny and invented a superior form of sovereignty. The American identity thus remains post-colonial, also perhaps pre-imperial. This self-perception contributes to seemingly contradictory impulses that have coexisted for much of American history. To be specific, the US affinity for intervention overseas and the US aversion to scrutiny from abroad. Such interrelations of subjugation and independence, of isolation and cooperation, of the internal and the international, pervade our world. Relationships of this sort may be found to some degree in and among all the member states of the United Nations. They pertain as well to non-member entities, such as Taiwan, Kosovo, and Palestine. It is in our efforts to re-stitch the remnants of colonization, and maybe in places like Kharkiv and Crimea, to confront a new colonial patchwork, that we, the members of the global community, are revealed as post-colonials. This is especially the case with regard to international law, the topic that structures the second strand that I pull from Professor Coomaraswamy's rhetorical tapestry. International law is said to have 4 fathers, a few Spanish priests, and our lecture's namesake, Grotius. The periods of colonization in which these men lived shaped their writings. In turn, their writings shaped, even justified, the colonial project. Grotius, after all, was, among many other things, a lawyer for the Dutch East India Company. His position in the colonial era is evident in his espousal of the law of prize. It also surfaces in his acceptance of slavery as a fact of the law of nations, albeit a fact contrary to nature, a practice that so-called better nations would do well to avoid. Our own international legal system operates in reaction to that colonial era. In the last half-century, the norm of equal sovereignty empowered new states as they emerged out of eroded empires. This dispersion of authority is apparent in bodies like the General Assembly. Yet, significant power still resides exclusively in certain states, most notably the Security Council's 5 permanent members, each of whom has, at various times, revealed an imperialist streak. Vestiges of colonialism, what Professor Coomaraswamy and many others have called double standards, remain hallmarks of our post-colonial epoch. We are thus in need of post-colonialism. To paraphrase Gayatri Spivak, not only must the subaltern be permitted to speak, but when she does, others must listen, must admit her as an equal to their ongoing conversation, and must eventually adjust their behavior to accommodate her place in their world. As scholars like Mireille Delmas-Marty have stressed, this process, a process that Adino Addis aptly labeled dialogic pluralism, must alter the structures of social and economic inequality within which the seeds of armed violence germinate. With this claim, I move to my third strand, a consideration of women and children. What did our putative forefather of international law have to say about women and children? His historical account afforded little relief to either. Included in the law of war, Grotius wrote, was a right to inflict injury that extended, and I quote, even to slaughter of infants and women with impunity, unquote. Yet his very mention of women and children hinted at a preferred rule, one that he soon made explicit. Children should always be spared, Grotius wrote, and so too most women. Among his most plaintive examples in support of this injunction is this question, written by another ancient Roman: for what crime could little ones have deserved death? Grotius typically portrayed women, no less than children, as innocents who should be exempted from the ravages of war. Notably, he included within this exemption a ban on sexual assault. Grotius acknowledged that many writers had maintained, quote, that the raping of women in time of war is permissible, unquote. He disagreed. Grotius insisted on what he called a better conclusion, enforceable, quote, not only as a part of military discipline, but also as a part of the law of nations. That is, whoever forcibly violates chastity, even in war, should everywhere be subject to punishment, unquote. These passages depict women and children as bystanders, beings not fully conscious of the world around them, not actors, but objects in the tableau of the battlefield. They are to be protected, rescued even, in service of the actor's notions of honor. A social scientist would say they have no agency. They are, first and last, victims. The depiction rings familiar almost 4 centuries later. Mark Drumble, Fenula Nihuelen, and Diane Otto are just a few of the many scholars demonstrating that the discourse of victimhood continues both to motivate and to justify global action on behalf of persons perceived as victims. Here too, then, remnants of a colonialist power dynamic persist in what is supposed to be a post-colonial era. What is to be done? Makers of post-colonial international law should aspire to deploy the tools of motivation and action in a way that avoids reviving outdated notions of societal honor, and instead honors the actual humans who endure violence amid war. This is the 4th strand that I draw from Professor Kumaraswamy's talk, not only because of her express mention of honor killings, but also because of her recognition that women and children is not a single word, that discrete attention must be paid to the many different hues of human experience. Victimization may be an aspect of that experience, but it is not the only one. Consider this sentence from the boyhood memoir of one who survived World War II, quote, children, even relatively young children, learn to be cunning or street smart when circumstances demand, and they are fast learners when they have to be in order to live another day, end quote. The author is Professor Thomas Bergenthal, whose career has included service as a judge on the International Court of Justice. Another backward glance reveals glimpses of Bergenthal's insight in Grotius' time, and not only because Grotius himself began the practice of law at the ripe old age of 16. Was there, in that time, any foremother of international law? An early president of this society, James Brown Scott, once cited, quote, "that noble woman who preserved him," that is Grotius, "for us and for international law," end quote. That woman was his wife, Maria de Groot. When Dutch authorities detained the couple as political dissidents, she and a maidservant stuffed Grotius in a trunk and smuggled him to France. There, he completed the law of war and peace. As long ago as the 17th century, Maria and her maid flouted the stereotype of passive womanhood. The same surely is true of two other women of that era. One is the Spanish queen who commissioned the voyage of Columbus. The other, the queen who waged war in England's first colony and built a global navy whose power encroached upon the Grotian tenet of freedom of the seas. These two monarchs contributed mightily to colonialism, the practice that Grotius and the Spanish priests theorized. If Grotius is a forefather, therefore, Isabella and Elizabeth are foremothers of international law. Perhaps it is in recognition of their ruthless reigns that Grotius stopped short of advocating a blanket exemption for women. To the contrary, he maintained that wartime violence could be wreaked against women who, quote, "have committed a crime which ought to be punished in a special manner, women who have taken the place of men," unquote. This and other Grotian references to punishment direct me to my final strand, accountability. On this, I fear that Professor Coomaraswamy is rather more sanguine than I. She cites with optimism UN monitoring mechanisms, Security Council resolutions, and International Criminal Court prosecutions. Yet it appears that the Council proposal, or at least one of the Council proposals, to sanction persistent perpetrators of grave violations, like recruiting or using child soldiers, has stalled. And although the ICC broke ground by convicting a militia leader of those very violations, it must be noted that two subsequent verdicts acquitted other leaders of similar charges, and that despite judges' findings that child soldiers were everywhere during the conflict under review. What is more, not one ICC verdict has resulted in conviction on any charge of sexual violence. Considered in light of developments at the Security Council, these facts compel us, first, to put to one side claims that legal technicalities explain the ICC verdicts. Second, to inquire whether we have entered a new era of soft, some would say no, accountability. And third, if the answer to that question is yes, to ask, what are we going to do about it? Parenthetically, this inquiry must explore the freedom from accountability that countries like the United States enjoy by dint of their P5 status. So where does this leave us? If not victim, who is our post-colonial child or woman? And how should international law both protect and empower her? Initially, we must accept that she may not be a she. This is an insight gaining currency in the last couple years, as states and organizations begin to address sexual violence and other wartime harms done to boys, and yes, even to adult men. Furthermore, there is much to be gleaned from the scholarship of Martha Feynman. It posits that what warrants protection is not sex, not age, but vulnerability. It thus refocuses analysis away from a singular identity as woman or child and toward the varied ways that all persons, on account of some traits but not others, at some times in their lives but not others, may be vulnerable. It is to those moments of vulnerability that she would direct the making and implementation of law. Feynman's focus brings into view an image that transcends both colonial and post-colonial assumptions of societal strata and personal predilections. It thus bears promise for the envisaging of a post-colonial future. Who knows? Maybe a global culture cognizant that everyone at times is weak will prove less eager to initiate armed violence, less apt to tolerate the violence done by structural inequalities, and more willing to construct a just and enduring peace. Thank you.
Thank you, Professor Ayman, for your thoughtful remarks, and both of you for the intellectual feast that we witnessed today. Your contribution will be published, allowing us for further reflection and study of the issues before us. And again, your presentations justify and show the vibrancy of the Grotius lecture, and we thank you for your presence here. I want also to thank, on behalf of American University, Washington College of Law, your presence, of all of you, and your interest, as well as the following individuals as institutions for organizing this important event. First of all, the American Society of International Law's President, Donald Donovan, and its Executive Director, Elizabeth Anderson. Let us, our hosts, for allowing us to use this impressive Ronald Reagan Building and International Trade Center, and Professor David Hunter and Julie Yorkshire of American University, Washington College of Law International Legal Studies Program, who have been instrumental always in the realization of this program. I hope all of you enjoyed tonight's lecture as much as I have, and I look forward to be with all of you in the reception that is going to be in the pavilion room after the president of the society makes a closing remark. So I invite President Donovan to come here. Thank you very much.
Knowing that I'm between everybody in the reception, I intend to be exceedingly brief, but I couldn't leave without thanking Professor Kumaraswamy and Professor Ayman for those remarks. I think, notwithstanding the at times sobering reflections, I think their careers, their scholarship and analysis, their in the trenches practice, and now their advocacy give us all hope that we may continue to make progress and maybe even an accelerated pace on the issues that you folks have addressed. So thank you very much for being here with us. And I want to thank Dean Grossman and the American University. I emphasized on Monday with my colleagues from the IALA, we opened this conference, that this is very much a true collaboration. And we from the American Society have been very grateful for the chance to participate in the committee work of the ILA and the like. I should, of course, recall that many of us in the Society are members not only of the American branch, but of the many branches from which we all come, given the international composition of the Society. So this conference, as you will see, will be a true collaboration. But you'll forgive me if I remark that the Grotius lecture, which I think Dean Grossman very appropriately calls the starting point, a good tradition is the traditional starting point of the ASIL annual meeting. And so if you've had a difficulty figuring out what you want to do to date, let me tell you, it's now going to get more difficult, because we're now going to superimpose one meeting on top of another, and the traditional ASIL meeting now begins. So we're off and running. In thanking American University and Dean Grossman for their support of this lecture, which is just a spectacular start, as we've seen now, to the policy debate and the intellectual exchange that this meeting represents. I also want to thank all of our academic partners, of which these folks are exemplars. We have some 50 academic partners from around the world. We rely on them not only for support, but to provide forum for ASIL programming. I was just a beneficiary of being hosted by the University of Geneva and the Graduate Institute in Geneva. It's an important part of ASIL's work. And if I may say so, I think Dean Grossman exemplifies what we're trying to do in another fashion. Just recently, with the support of American University, with the Society, and with additional support from the IBA, Dean Grossman, as chair of the Human Rights Treaty Bodies chairs, convened all 10 here in DC. It was the first time those chairs had convened outside of New York or Geneva, and the first time they'd convened under non-governmental auspices. And their objective was to provide a joint position with respect to the strengthening process of the Human Rights Treaty bodies that was underway, to ensure that, in fact, the process, if I may say so, indeed strengthened the Human Rights Treaty bodies. And under his guidance, those chairs produced a joint statement, a compelling statement, which I think did indeed have an impact. So if we're going to talk during this week about the effectiveness of international law, I think Dean Grossman is one of the folks that we can look to as leading the charge. So, and the American Society was grateful to be a part of that. So, welcome all again. Thank you again to American University. Thank you again to Professor Kumaraswamy and Professor Amen. And now we can all go to the reception. Thanks.